Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
Over the years, we have done a series of programs in our 30-year existence dealing with law, and one of the series was called Know the Law, and we got very good reception to our discussion with attorneys about important questions. That was some years ago. I'm very pleased to announce that we're going to do a series of programs now concerning legal questions, and it is such a privilege to welcome to the program a friend of mine for a very long time, Mr. Glenn Walker from Coeur d'Alene, Idaho. Glenn Walker served with distinction and honor as the prosecuting attorney of this county for many years. He's now back in private practice where he deals with both civil and criminal law. While he was prosecuting attorney, he was the first prosecutor in the state of Idaho to be able to obtain a conviction under what is called the Idaho anti-malicious harassment law through a plea bargaining. And so he was very, very supportive of strong enforcement of the law and protecting victims. He's here now for several weeks to discuss different aspects of law and questions of ethics and how best to use the law to promote our democracy. Glenn, we've had you on the program in past years, and we're very happy to have you back again.
Happy to be here.
It's very hard to know where to start. You've had so many really renowned cases, and both when you were a prosecutor and both now in private practice, and of course you have a law firm with other attorneys. But I think on the first program, we're going to get into some of your practice lately where you've had some new experiences. And that's one thing exciting about law, that you can have expertise, but you can expand those. And so let's spend some time on something that's become more of an issue. We hear a lot about this on national programs, and that is that more and more people are marrying men and women who are different nationalities, and they have children, and then in some cases divorce takes place, and there's a great question about custody of those children. It's complicated enough if there's a divorce and one parent is living in California, another one in Idaho. We know those are some difficulties, but this is even greater. And there's been some international laws dealing with this, such as the Hague Conference on Private International Law Convention, and there's also the United Nations General Assembly has rights of children. And so a little bit of that background, let's just proceed into some of your experiences about what happens. I guess my first general question would be, what is the starting point when there is a parent in one country and a citizen in that country, and there's a parent in another country as a citizen in that country, and the child is underage or children? As an attorney, how would you start looking at, from your perspective, whichever parent you would represent, the legality of trying to represent that client?
Well, that's a big question, Tony, but I'll try to start and relate it to a very interesting recent case that I had. The Hague Convention on the civil aspects of international child abductions is the governing body, so to speak. Was adopted in 1980 and went into effect in July of 1988 under President Reagan. The United States government, Secretary of State George Shultz was a strong advocate for it, and it was adopted by the Senate and signed into law in the United States. And basically the idea is if we didn't have some international body, if there was a dispute between American citizens and citizens of any other country over a child, American citizens would have to go to that foreign land, hire a lawyer in the foreign land, often and maybe generally dealing in a foreign language, and certainly foreign countries, oftentimes very, very alien cultures as well as foreign languages, and it just was absolutely unwieldy. So the Hague Convention on the abduction of children allowed us an authority, a place to go. Under the Hague Convention, the state where the child is at the time of the inception of the case, the country where the child is at that moment, has an obligation to do something. and you first determine where is the child's habitual residence. And from that, you start a process down the line. In the case that we were dealing with, the child was 12 years old and was a citizen of the United States. The wonderful child, I represented the mother, and it was a privilege to represent her. I felt like her cause was just, the child's cause was just, and he very much wanted to stay with his mother. How do we get that done? The child, unfortunately, from a legal point of view, the child had been residing in a foreign land for 11 years, and he was 12 years old. So under the Hague Convention, that foreign land was the state of habitual residence.
I'm going to say that in the convention, there's different provisions for both sides to argue, but habitual residence was an important point.
Habitual residence was fundamental, and we had arguments against habitual residence because it was our position that the mother had been basically forced to remain in that country. And under United States concept of due process and the United States concept of fair play, we would not be willing to concede that that was a country of habitual residence because it wasn't voluntary. But nevertheless, you go to the country of habitual residence, and the child is supposed to be returned to that country. So that's what we started off with. Even though the child was a citizen of the United States, he was also a citizen of the other country, which is typically the case, where you have, as you indicated, foreign nationals marrying each other. You have dual citizenship traditionally. We had a great deal to lose if we had gone to trial because the child, if we had lost, that is, the child would be returned to a very alien culture he did not want to be a part of. He wanted to be in America. He wanted to be with his mother.
So now, and you didn't go to trial?
We did not. We resolved the case through negotiations, sure. And by the way, that happens about 95% of the time.
In these type of cases?
In most any case.
Okay. But if you're in trial and in this case, of course, federal court.
Federal court.
Because you're dealing with international questions and treaties and conventions, and our Constitution could play a role too. How would you approach you've already partially answered it, but how would you approach the habitual residence when, I guess to complicate matters, obviously one parent's born in one country and a citizen in that country, the other parent's born in another country, citizen in that country, but then the child oftentimes is born in one of the two countries of the mother or father's citizenship and residence, but winds up living in the other country. Does that become a factor of importance in trying to argue the case if you're particularly trying to combat habitual residence records that have been, the overwhelming majority of the time the child's been in one country of one parent, but was not born in that country?
Yes, the child in our particular case was born in the United States and got United States citizenship by way of that, but had been living for 10 or 11 years in the foreign country. And again had the citizenship in that country because his father was from that country. But we had to fight that habitual residence. Now, there are other provisions of the Hague Convention.
Let's identify some of those.
There are other provisions of the Hague Convention that you can work with. For example, our child was 12 years old. There is no magical age that a child can speak his own mind and determine where he's going to be. It's on a case-by-case basis, and the judge has tremendous discretion to allow or disallow a child's wishes to prevail. But this child, in our particular case, very strongly wanted to be in the United States and had gone through psychological examinations and had testified previously or spoken to judges previously of his wishes to be in this country. So the child's wishes are extremely important, and at age 12, it becomes a real serious question as to whether or not this child's wishes should prevail. We felt certainly if the child were 14, we would have been hands down winners on that. At age 12, it's a debatable issue, and it could have gone either way as to that one issue. And another one, in addition to the age, is, and most important, is whether or not the child would be subject to adverse psychological or physical consequences upon his return to the country. One of the things that we had in that particular case is that child would have been stop listed from leaving that country if he had ever gone back to that country. So that's alien to American way of thinking. Basically, he would become a prisoner of that republic. And we didn't certainly want that. So the fact that if he had gone back, he would have then been subject to mandatory military service. Essentially, the Hague Convention stops at age 16, so it's children under the age of 16. But the child would have gone into the military at age 18, and they would not have allowed him to leave the country between age 16 and 18 because of the fact that he's going into military at 18. He essentially would not have been able to leave that foreign country until he's 20 years old.
Then once he served in the military of another country, would he still have his status as an American citizen after that point, or is that in a question?
Well, it's a fascinating question, Tony, and we spent a lot of time on that. And we ultimately, after research, reached the conclusion that he would not have lost his American citizenship because of that, because of the fact that he would not have been doing that voluntarily. In other words, he would not have been leaving the United States for the purpose of going to serve in another military. In fact, he happened to be a dual citizen, and he had no choice. That's a different situation, not like the young man who served in the military for the Taliban in Afghanistan.
He did that voluntarily, and he
Correct.
Was only a citizen of one country, and he
Yes.
chose to do that.
But I can assure you that that was an area of concern, and we spent a lot of time on it. And you can imagine how a mother or father, if that the case may be, how a mother would feel about having her child taken from her and taken to a foreign country, where she herself had been fighting to leave that country for so many years. She then could face the prospects of not seeing her 12-year-old son until he's age 20.
You've used another benchmark here, and that is age 16. Suppose a couple's married and they divorce, and again they're in two countries, and the question arises, and yet the person's, from our perspective in this country, I know other countries may be different, but the age of majority is 18, and suppose the child has just turned 17, and then there's a dispute of custody and residence. Can that child then make his or her own decision because they've passed the age of 16?
Yeah, well, the child could leave or not leave, but the problem that you often face is if there is any kind of a custody dispute, the child may be stop-listed from leaving that country if there's any kind of a dispute going on.
Because the court can still award custody to one of the parents until they reach 18.
That's correct, but it's just that the Hague Convention cannot be used for the return of a child if he's past age 16. But custody laws are still in effect certainly in the United States, and I would imagine in most countries up until age 18. It's just that they're not often used because children vote with their feet when they get that age. They go where they want to go for the most part. But if there is a dispute going on, however, there may be a no-exit order on the child, and he may not be able to leave. We certainly felt that would have been the case here.
The other complication would be here if a divorce takes place and the child is 17 and they're stop-listed and can't leave the country, then even though they could leave at 18, unless in the country where they may be drafted into the service. Of course, in this country, United States, you can't be drafted until you're 18, if I understand it. But if they were drafted into a military in that given country, then if that country has a rule, what in your case, I guess it did, they might be drafted in at 17, have to serve in the military to 20 or 21.
Well, we expected that he would definitely have been in because service is mandatory, and he would have served for 2 years, so he would have been age 20 before he would have been able to leave the country, and he's only 12 now. Essentially, it would have been a lifetime, and the child essentially would have seen it as involuntary servitude, and certainly the mother would have. I felt, by the way, very, very honored to be able to represent her, and this may be a subject for a future show, but essentially, to my way of thinking, I was representing the child, although the client actually was a mother of the child.
Because of the legal age question.
Yes.
And the dispute there. Something else that, in my very brief review of data, and not certainly being informed well or expert in this field, but there is in the convention a provision talking about the maturity level of the child. And again, you were very fortunate to have a client who was, or two clients, the mother and the child, that were very, very intelligent. In this case, I understand from you and others that this child was very, very mature. People mature at different ages. So doesn't the convention also make a provision that the court at least has the permission to talk with the child, and that maturity of the child can be a factor even before they reach age such as 16?
Yes. I've had, I couldn't begin to count how many custody cases that I've tried over the years,
Sure.
And you rarely have a child testify in a trial. I've had children 10 and 11 testify. I know of cases where children have testified younger than that, but most cases it doesn't have a great effect. In this particular case, the child was 12 years old, and he was a brilliant child of brilliant parents. His mother had done most of the work in raising him and had done an extraordinary job. Tony, it was really much like sitting down and having a discussion with a graduate student. What a pleasure it was to just have a conversation with him. He was subtle, quick, witty, and extremely bright. He obviously had suffered because of the dispute between mom and dad, but he knew where he was, who he was, where he wanted to be. If this child had testified before the United States federal judge, I have no doubt that the judge would have felt compelled to allow him to stay here. So we felt good had we had to go to court. Nevertheless, we tried to reach a resolution through compromise of our case that would have gotten us to where we would have been had we gone to court. I think we did that, and we saved the child from having to go in and testify. The maturity level is crucial. This child had the maturity level. Many times a 12-year-old will not have, many times a 12-year-old will appear like a 12-year-old. This child did not appear like a 12-year-old through dealings with the child.
One of the things that's so exciting about practicing law is there's so many arenas and so many areas. You know, we have dual court system, states and federal, and we have civil and criminal law, and you certainly have a great background experience both in private practice, and you've represented defendants, you've prosecuted defendants, and now this has been a really big new arena for you. As you've looked at the convention, the Hague Convention, and I think you gave some attention to the United Nations rights of children also. Could you clarify a little more for our viewers why these conventions are needed and what countries that belong, you know, that are partners in these agreements, why they feel it's necessary to, for sometimes I believe I can say that in a custody case, a particular country will send a child back even though there may be reasons not to do so, but they were so particular about living up to the agreements because they may have children in that country too that want to come back to this country.
Well, yes, as I mentioned a moment ago, if we didn't have something like the Hague Convention regarding the return of abducted children, if we didn't have anything like that, and an American citizen then had one of our U.S. citizens, one of her children or his children, taken to a foreign country, could be one of the Middle Eastern countries or anywhere in the world for that matter, our citizen would have to go to that nation, fight for the return of that child in that nation's courts. In other words, go through a custody trial in that court, in that foreign language, in that foreign culture. With this, we have an international governing body of law where there are certain standards that have to be met. Again, first of all, if the child lived in the United States and that was a state of habitual residence, then on the surface, that alone would be able to cause us to bring the child back to this country. If we didn't have the Hague Convention, then a child taken from this country to Germany or France or Iran, or I don't think Iran is a member nation, or Cyprus or wherever it is, if we didn't have this, we'd simply have to go and deal with that country, and we might or might not be able to convince the family law court where we went that that was the right thing to do. But the Hague Convention does not deal with custody per se. It deals with where the child is supposed to live, what his residence is. You then determine the right country to have a trial. If you, for example, determine that Germany is the nation of habitual residence, you first use the Hague Convention to determine that.
And so, in fact, child's in another country, and it's determined that's habitual residence. Then the child goes back to that country, and then the courts in that country decide custody.
That's correct. And if you determine through the Hague Convention, in other words, in this particular case, the child was in the United States in Coeur d'Alene, Idaho. So we went into federal court, and here in our federal court, we would determine what is the nation of habitual residence. And once you determine that, then you would determine custody. But first of all, you determine the habitual residence.
But when that court here determines habitual residence, once that's determined, then the rest of the decision has to be in that country, right?
It has to go to that country, right? Now again, before you go back to the nation of habitual residence, again, there are, as I said, there are defenses to it. If the child is of sufficient age and level of maturity to testify, the child can testify to his or her wishes about going back, and the older the child, the more likely the child is going to be listened to. At age 10 or 11, probably not. At age 12, a good chance he would be listened to, and so forth. And again, if it appeared, and you could show that that child would have been in grave physical or psychological danger by going back, mistreatment, and again, you would look at American standards when you're talking about mistreatment. Those would not necessarily prevail, but that's what we would look at. So you look at habitual residence, but then there are exceptions to it.
There are other provisions or articles in that process.
Yes.
Well, let's suppose that, and this was true in your case, that the first thing a federal judge may have to do, in other words, doesn't, again, correct me if I'm wrong, because I'm treading on water that I'm not familiar with, but if you're about to have a hearing and the federal court or the federal judge decides, or can the judge decide, that there won't even be a hearing about the merits of the case. Does the judge just have the power to say, particularly when the U.S. government may be saying through the proper channels, this child needs to go back. So can the judge just cut it off and say they're going back?
Well, reading through a part of the Hague Convention, it appears that a judge has indeed the power to just say that in other words, the petitioner, the one who is seeking the return of the child to the foreign land, the petitioner would say the foreign land is the nation of habitual residence, and the judge therefore should send him back. And to a point, as you read the Hague Convention, it appears that that's what the federal judge must do, or whatever the nation is where the child is, that court must send the child back.
Let me just interrupt to say, particularly if, say, the United States, in the immigration and the exchange of the convention agreements, if our government takes position, this is that another country is the habitual residence, then does that put pressure on the judge to say that to stay in harmony and agreement with the convention, that we shouldn't even have a hearing on the merits, that the convention is prevailing and the child should just go back?
Well, at first glance, as I was saying, at first glance, it appears that the judge has to do that. However, as I indicated, there are those exceptions, and so what really happens is, instead of the judge just automatically sending the child back, the burden shifts over to the child, or rather the child's parents or custodians here, to show that there would be psychological or physical harm, and or that the child's physical or maturity, psychological, emotional level is such that his wishes should prevail. Now, if you can't have a hearing, you would have no opportunity to show that he was in physical or psychological danger. You would just be saying it without putting on any evidence. So it appears at first glance that the judge is required to send them back, but then when it sets out these defenses or exceptions, then it becomes quite clear without saying so that you obviously do get a hearing, because you would never be able to show it without a hearing. I don't know if that makes sense or not, but as often it appears a little gray, but the reality, the bottom line is you do get to have a hearing if you are alleging psychological or physical damage, or that the child's wishes have to be heard.
Or the child had a habitual residence without his or her wishes.
Well, that was an argument that we had in our case, and we didn't know how that one would go, but we would have to have a hearing in order to do that. And we didn't know how a judge would receive that.
Where that would be covered by the convention.
Yeah, we didn't know for certain that a judge would allow that argument, but we certainly were going to be very, very aggressive in alleging that.
From your experience in this, and I know you talk to others that have background in this and other counsel and attorneys, but do you think that in most cases like yours, the type of case, that judges have a tendency to have the hearing if it's not settled outside of court?
Yes, I do.
And so I believe you reached that point with your case. The judge had decided to have a hearing. Is that correct?
Well, again,
or did you reach that point?
We got to the hearing, but what we did is we reached an agreement which allowed the child to remain in this country and made the United States the country of habitual residence, which was the huge battle that we won. And so with that, then, if the Hague Convention were ever used in the future, it would be used to return him here to this country. And also...
So through that agreement, it's reversed it to where that the convention now is on your side, that is declared that this is habitual.
Right. Now our agreement did that, so we obviated the need for the hearing. But again, we never actually had the hearing. We got to the hearing, never actually conducted it, because what we did was present our agreement to the court.
So the judge didn't get to the point, the federal judge didn't get to the point of saying we will or will not hear the merits of this case?
No, but I'm confident he would have, Tony.
Okay. And that assisted you in the process of negotiations. Now that you've looked at this in great detail and spent lots of hours on it, what is your overall feeling of the Hague Convention as it relates to this particular issue?
Well, I have to confess I didn't know anything about the Hague Convention prior to this. I worked in a lot of areas of the law, all kinds of trials, civil and criminal, through the years, but I had never been really involved in that. I knew of it, but only in general. I found myself fascinated with it. I found that it worked in our case. We used the Hague Convention because our facts were strong. And in most areas of the law, Tony, we find that for most part cases are fact-driven. Our facts made it work for us. But I can also imagine scenarios. Maybe the child was 2 years younger, for example. Would we have been able to prevail if the child were 2 years younger? I don't know. And quite frankly, that would have been a scary situation if the child were a couple years older, a couple years younger. So I don't know how strongly I would be in favor of it if that were the case. But I think ultimately even then I would, because American citizens having their children taken to a foreign land, we can use the Hague Convention to have the child returned to this country. Without it, we would have to fight in German, in French, in whatever culture and language.
I have to bring our conclusion. Unfortunately, we're out of time. The good news is you'll be back next week and we can discuss this and other issues on that program. Ladies and gentlemen, we're so pleased to have Glenn Walker with us on a series of programs. He is so highly qualified to deal with this and other intriguing questions, and we hope you'll be watching this series. You'll learn a lot about the legal process. Until next week, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
I'm so pleased to welcome you back to the second week of a series we're doing with a person highly qualified to talk about a very, very important topic, and that is understanding and appreciating law, both the high law, the Constitution of the United States, and what we call ordinary law, fundamental law, and then ordinary law being the statutes. Last week on the program, our guest Glenn Walker discussed with us some experience he's had recently in expanding his knowledge in the field of law, and that has to do with the Hague Convention and dealing with custody of children who have parents in two different countries and citizenship in different countries. Glenn Walker was a distinguished prosecuting attorney, I would say as effective prosecuting attorney as we've had in Idaho in any county. And while he was prosecutor, he was very instrumental in getting laws passed dealing with what we call hate crimes. And he got the first conviction under the Idaho anti-malicious harassment law. He's now in private practice, both civil and criminal, and as I indicated on the show last week, he's recently just concluded through settlement outside of court a fascinating case dealing with custody of a child between the United States and another country. Glenn, thank you for being back. And
thank you.
I was intrigued with your knowledge and the importance of this question, because there are more and more couples in the world where they are citizens of different countries, and when divorce takes place, where is the child? And I'm not going to repeat last week's program, but I have a couple of follow-up questions for you. We ended the program by indicating that there was a real purpose for the Hague Convention, and without the convention, like for example, if a child in the United States was taken out of the country without the permission of the other parent of the courts, without this convention, you'd have to go to that country. All the legal things would be there, and through this agreement, they, under the habitual residence, they might get back and have the case here. Your case was one in which both the mother and the young son were citizens of the United States, or born here, and the father was born in another country. And we'll leave it there at that. But and the child had been there and it was here now. And so you prevailed with your negotiations. The child stays here. But let's take a case that's, I want to tap your knowledge in relation to the most famous custody child case ever in the United States, and that's Elian in Florida. And Attorney General Janet Reno had I guess a painful time during that process. And the child was in Cuba, was a Cuban citizen, and the mother and the child with others fled the country under the communists, and she and others lost their life on the sea, and he was rescued, and the father won him back in Cuba. Tell us a little about how that case is different from yours, and how the international agreements would work.
Well, the Elian Gonzalez case is certainly one of the most fascinating cases we've had of any kind in law in the United States in the last many years. Certainly if Elian Gonzalez had been an adult, he would not have been forced to go back to Cuba because there are hundreds of thousands of others who've been in that exact situation. And had his mother survived, he then as a minor would not have been taken from his mother and sent back. But the Hague Convention for the return of children abducted did not apply because, and if it did, then the father would have come to this country, used the Hague Convention to get the child returned. There were certainly similarities, but the United States, in the spirit of the Hague Convention, almost was compelled to help that child return to its country of habitual residence. So there certainly were similarities, but there are obviously differences too. The father was a Cuban citizen, the child was a Cuban citizen. Again, if it were an adult, he wouldn't have been forced to return, but you see, by not returning the child, then you're literally taking the child from his only surviving parent. And that was something ultimately the courts just could not do.
So both the Justice Department and the courts agreed that
Yes.
that was the child was to be with its surviving parent.
Yes, and as much as we hate the idea of any child being taken and returned to a communist dictatorship, nevertheless, you still couldn't get past the fact that this child didn't know anything about democracy or communism. The child only knew that he has two parents, and one of them died, and he had one surviving. And almost any theory of family law, the child had to be with the father.
And the other issue here, I would suppose, was the child was very young.
Child was only 5 years old at
yeah.
the time and 6 at the time he was sent back.
Mm-hmm. With that, we're going to move away from this very fascinating and complex issue of custody of children internationally. And we want to move, for this program and the other programs we're going to do together, to domestic law that you've been involved with for many, many years. The rule of law. For our viewers who are not attorneys and but have great interest in and are impacted by the courts and decisions, what would you say to our viewers about, from a philosophical legal viewpoint, what the rule of law means in a country such as ours under our democratic system, and there's a priority and hierarchy of law? Let's just start with what is the rule of law.
Well, of course, the rule of law in a democracy is fundamental. We have dollar bills, $5 bills, $20 bills. They're just pieces of paper It is our faith in our rule of law that makes them have any value. So the rule of law enables us to have our free market economy. The rule of law allows us to have our education system. The rule of law keeps us from anarchy. It gives us a system. It allows us to have hopes and dreams. I mean, it is fundamental to any citizen. And for that matter, it would be in any country, except that you have to have belief in it, and it is the pillar of our democracy, the rule of law.
And you're very clearly stating that for it to survive and for it to function and have a hopefully fair but orderly society, and that there has to be from the citizenry a belief in and faith in that law.
Faith.
With that, let's talk about now the structure and order or priority of law. You know, we break it into two categories. We talk about fundamental law, and we talk about ordinary law. Would you involve yourself in edification of our viewers by talking about the difference between those laws and how you as an attorney and others understand that when you are, if I can just elaborate a little bit more, you have a client and there's, you know, you're interested in the procedure and the procedure's been followed properly in either civil law or criminal law, but you're also interested in the substantive issue of the law itself, you know, and maybe some law comes into conflict with other laws. So if you'll just take us through the order of law.
Well, that's a broad question, Tony, and I'll just take a bite or two and see where it takes us. Our law comes down from the English common law, so we have hundreds and hundreds of years of tradition, and that's how our law got going. And then gradually, that's the fundamental law. But then gradually, we started having laws passed in this country, and that's your ordinary law, the statutory law, and case law. But the law is put in place to make a society be ordered and be functional. And we look to both substantive law and procedural law. I mean, the substantive law is what does it say? What are your rights? How are things to be done? Essentially, procedural law tells you how to get there. It's very complex, and the lawyers are self-governing, but fundamentally controlled by the Supreme Court in every state.
You know, when you are representing a client and they come in and they tell you what the concerns are, I think of attorneys this way, and I want you to elaborate upon this. I'm a great defender of the importance of attorneys in our system. I think you really are the guardians of the fair application of the law. In other words, you're the ones that go into court if someone's been denied either a procedural right or looking at the content itself. Some, you know, legislators are not above passing a law that the content is unfair and violates the Constitution. So would you just take a reaction to my comment about how you are guardians of both those things? That, in other words, you only have to win on one of those in court. You know, if your client's been denied a procedure, or if the police have done something wrong, or if there's been an improper way of selecting the jury, or you read a certain law and you say, well, the police have done everything correct and the prosecutor everything correct, but the law is lacking. That's very long and elaborated, but you are guardians.
Well, yes. Take for example, it applies in civil law and criminal law, but take a criminal law issue, for example. People ask, well, how could you defend someone charged with whatever the crime might be? Well, I guess the answer to that is that what we're trying to do in this free country is to make certain that the law is followed, and that people who are charged with crime are held accountable. But you also want to make certain that a person is not falsely accused, because that would be fundamentally anti-democratic and therefore fundamentally anti-American if in fact a person could be falsely accused, could be taken from his home by the militia, by the police, held in seclusion, isolation, etc., and possibly falsely accused. So in order to make a democracy work that can have the faith of the people, there has to be these fundamental rights embedded in it. And so We know that we're not going to do anything to violate the law, but we cannot guarantee that we're not going to be falsely accused. And if we were to be falsely accused, or our son or nephew were falsely accused, we would want him represented as zealously as the law allows, and that is the role of the attorney in a criminal case, and is fundamental. We would have no democracy if we did not have lawyers in the criminal justice system, and yet those people oftentimes end up being the most unpopular. But the truth is, they above all are really defending in the most unpopular way our greatest of liberties. That's just on the criminal side, and of course the same thing applies in the civil side. People can be wronged despite any and every good intention of their own, and they have no way to help themselves without lawyers.
A contract is not carried fully through and someone's been injured, but the contract, or in employment, someone's been dismissed, and sometimes those dismissals, of course, are proper, and sometimes they aren't. And if you don't have due process, and there's not some mechanism, wouldn't it not be clear to assume that the abuses would increase by some people? They would say, well, gee, there's no avenue they have. I can do whatever I want in relation to their employment.
Well, sure. Even as we're young children, 8, 10, 12 years old, there are bullies on the block.
Sure.
And those bullies on the block are only going to be warded off when someone stands up to them, or when several of the young children get together and they have a defensive band or something like that. Well, lawyers can provide that function. They can be there as trained and learned spokesmen and women and functionaries for the rights of the individuals against the bullies or the would-be bullies.
My next question I've heard, and you're going to consider it quite an unreasonable statement, I would myself, but I've heard people say, why are we so particular about, under our judicial system, procedures, and only guilty people are arrested, and so we're tying the hands of the courts and all. Isn't that assuming that there is somehow in one area of our society, that is in law enforcement, there are never any mistakes?
It's tragic that a person in the United States could be convicted of a crime falsely, but unfortunately we find every year many people who are wrongly convicted, and in fact we are finding through DNA testing and other things every year we are finding a number of people who not only falsely convicted, but falsely convicted of murder and sentenced to death. It is unfortunate, but we know that it is happening now, and we are proving these things now scientifically beyond any doubt, and we have every reason to believe, therefore, that throughout this history of this great country, we've put many people to death who were innocent. There can't be any other conclusion. So yes, it does happen, and I was speaking just today. I go to breakfast about twice a month with a great friend of mine, a minister in this area, and he was telling me about an elderly man in his church who is in fact retarded. This man was convicted of all things horribly, what sounds horrible, lewd conduct with a child. The man's mentally retarded, and this minister was telling me of speaking to one of the jurors after the trial, where the juror actually said, well, you know, he must be guilty of something or he wouldn't have been here. So it's just the idea of being charged is so horrendous to so many people that they automatically assume guilt, and they can't get past that idea of where there's smoke, there's fire. But that's fundamentally wrong and fundamentally anti-democratic. The reality is a person in the United States is presumed innocent until proven guilty. And so if a juror reverses that, then she essentially puts the burden on the defendant to prove his guilt. And many people in this great country actually today, Tony, believe that a person has to prove their innocence. That's absolutely exactly the opposite of our Founding Fathers' intention.
And that puts a great responsibility on the judge, for example, to
Yes,
make
it
sure
does.
that jurors and lawyers can address that also. When you deal with modern technology, and you have prosecuted many people, you were a prosecutor for a long time, and by the way, you were very successful. And,
Thank you.
And you also got some people off the street that were very dangerous, that it was proven they were guilty. You've also had some very successful cases as a lawyer defending people, as a defense attorney. With this new technology, and there's lots of different kinds, but particularly DNA, I'd like you to elaborate a little bit more on that. Isn't this really a gift to both the prosecutor and defense attorney? Doesn't this increase the chances, if it is used in cases where there is DNA, that we're far less likely to even proceed with prosecution of someone that would be innocent?
Well, you know, Tony, I might be a bit of a dinosaur in some ways as I look at some of this, but I believe I believed when I was prosecuting attorney, and I fundamentally believe today that the greatest defender of the liberty of our citizens should be the prosecuting attorney. The prosecuting attorney, I used to say, was the real and true public defender, in the sense that he or she represents all of the people with the absolute moral and legal obligation to make certain that that people are convicted if they are in fact guilty, but never to convict an innocent person, to always make sure that a person is not wrongfully charged, that it never gets to court. I hate to see prosecutors say, well, we'll let a jury decide. Wait a minute, the jury knows nothing of the law. They learn of the case. They never saw the case until they walk in the courtroom, and the prosecutor has lived with that case for months or years. The jury walks in, the prosecutor must be right. He then has to be a good persuader to get the jury to follow him, but first of all, he must morally be right. And many prosecutors today don't understand that, and they say, well, I've got probable cause to believe it. That's not good enough. A prosecutor should be morally convinced in his own mind or her own mind beyond any reasonable doubt that the guilt is there, not just leave it up to jury to decide, because the jury might make a mistake and a person have his or her liberties taken from them without justice. Now, there can't be any justice where that happens, and unfortunately, the prosecutor is often not the true public defender. In fact, he is just, and I say just, a public prosecutor when that happens. He has to be guardian of liberty.
It is not a game.
It is not a game.
It's not a score of you've had X number of cases in the courtroom. In other words, when the jury has to deal with beyond a moral certainty, beyond a reasonable doubt.
Right.
You're saying the prosecutor needs to do that in looking at the decision to whether even to come forward. For our viewers outside of Idaho, some states are different than ours. The prosecutor has that great power of something called information, that you can actually bring the indictment. In states like North Carolina, where I grew up, you can't do that. A grand jury does the indicting. So in a state like Idaho, in relation to what you just said, there's even more weight upon you to decide, is there evidence enough to proceed? Well,
that is correct. You mentioned the words moral certainty. That's also, as you indicated, that's kind of another way of saying beyond a reasonable doubt.
Yes.
Or, how do you get to the concept of beyond a reasonable doubt? Well, if you feel it in your heart to a moral certainty, then you have taken reasonable doubt away. Not take all possible doubt,
right,
but to a moral certainty. That's a fundamental thing. Now, if the prosecutor is just an advocate, just taking a position the same as the defense attorney, in other words, he may or may not be right, but he should be a good public speaker. He should be a person with good verbal skills and the art of persuasion, and the jury is not going to know. But they know he's supposed to represent justice. So there's going to be a natural inclination to want to go with him, plus a natural inclination to want to rid our streets of any crime. So if the jury goes that way and substitutes those kind of feelings for moral certainty, then you run the risk of convicting innocent people. And the idea of this great country sending a person to his death who isn't guilty, well, it ought to be too much to even comprehend. We should not want to be rid of crime so bad that we would do that. And I say we should not want that so much because none of that is necessary. Mm-hmm. All you have to do is have a prosecuting attorney with absolute strong moral convictions and prosecute only those cases that he knows in fact are guilty. Don't just take a chance and maybe the jury will find guilty, because maybe they will find guilty where there is no guilt.
While we're on the issue of prosecution, and we'll have on the probably next show, we'll be talking about some on the defense, but we're also going to talk on the next show about some philosophical issues about the ethics in law and the ethics and obligation of attorneys, not only representing their client, but their commitment to constitutional principles, which I've heard you say, and other lawyers that I know, that there are certain cases you have that remind you why you became an attorney. There's such great victory there for the democratic principles. But on another question relating to prosecution, isn't it very, very important that, and I know that there are two parties, the prosecutor representing the state and the defense attorney the other one, but don't both attorneys have a very ethical obligation to try to find a jury that's truly impartial? You're not trying to load people on the jury that's got their mind made up. That's the last thing that would be justice in a society. How do these two attorneys, working with the judge, and by the way, I think we have some very fine judges in North Idaho. I've been so impressed with their procedures. But talk a little bit about jury selection.
Well, jury selection may be the very most important part of the process, and that, along with opening statement and closing argument and direct and cross-examination and everything else, is. But seriously, I regard it as exceptionally important. I don't believe most attorneys put enough of emphasis on jury selection, and the reason is because it's so hard. It's so hard to try to find that fair and impartial juror, and the judges and the court system, the way it's laid out, really don't want to spend forever going through it, and it's boring and it's tedious. But you sit there, you go into a room, and you have 30 or 40 people in a panel, and each lawyer addresses the jury. They don't address the jurors one at a time. They stand up and they talk. In other words, if I'm the plaintiff's attorney or the prosecutor in a criminal case, I go first, and I speak to the jury, the entire panel all at once. Mm-hmm. I try to engage them in discussions, and it's awfully hard. People aren't going to want to, they're in a room full of people that they've never met, and they're asked to start talking. The lawyers say, well, we're not going to pry into your private life, and then they start prying into their private life. So the people are not going to want to respond, so they don't say much of anything.
Or if you ask a question, do they raise their hand, even if it's pertinent to them?
Right. So you want to get a dialogue going so that the attorney doing the jury selection, we call it the voir dire process, to seek the truth is what these words mean, but to try to find out what the jurors' passions and biases might be, because the last thing you want is somebody who has an axe to grind on the jury. You're trying to find that person who doesn't know anything about the case, and if he does or she does know something about the case, they would put that aside and apply the law fairly, and not really want, quote unquote, want to serve on the jury, but somebody who really is doing it out of duty, and that's all. Well, it's extremely hard, you just, when it's all over, you've got a few people that you can remove without any cause, and how in the world do you know which ones are going to be fair? So each side then tries to eliminate those people that it seems most likely to be against them. Because if a person seems like he's going to be with you, the other side is going to remove them. Mm-hmm. And you have to expect that. So each side then is trying to remove people who appear to be or leaning to be, through body language or verbal, against them. A tremendous art, very poorly developed by most attorneys, and I've made plenty of mistakes there myself.
And the judge is sitting there trying his or her best to also make sure someone's not on that jury. And the judge can ask questions too.
The judge can ask questions, but generally the judge will only ask questions when one attorney or the other challenges somebody for cause, and that, I mean, they ask to have somebody removed because of a stated bias of some sort, or relation or something like that. Then the judge will try to find if that bias could be set aside. But other than that, the judge won't ask questions, and the judge will try to keep a person on the jury if he can.
Yeah. because if you run out of potential jurors, you have to go out and find some more.
Right.
How about jury consultants? Some of the famous law firms in America today are hiring consultants, and I hear sometimes they're very helpful to the attorney as you're trying to select a jury.
Well, the practicing law is certainly, to a large degree, the art of applied psychology. I've never been blessed with the money on a case to hire a jury consultant, but I've certainly always wanted to, just to see what they might be able to tell me. But I have to be a good enough amateur psychologist myself to be able to figure it out. And I've always said it takes two things to be successful in a business or avocation or profession, and that is common sense and a feel for people. If you've got that, you'll be able to pick your jury, whether you've got a psychologist with you or not.
We're out of time, but you certainly have been successful, and I think year by year one learns more and more about the process in juries. Glenn, thank you so very, very much.
You're welcome.
Ladies and gentlemen, the good news is that Glenn Walker will be back with us. We're continuing this series on the law, and we're going to deal with a lot of philosophical questions and the meaning and content of law, and what makes law fair and reasonable, and what makes a law unfair and therefore in violation of some great principle under the U.S. Constitution. That'll be some of the issues that we will deal with next time. As I've said, this series will go on for another couple of weeks. Hope you'll be with us. Glenn is a great guest, and we hope you'll be with us. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station.